All right, welcome back. This is the capsule on Chapter 2, the beginning of Chapter 2, which we look at for the first week. So this is the second of two capsules for week 1. Most of Chapter 2 we're actually going to look at next week. And we conveniently stop here at the end of this capsule in the middle of a test, which is the test for the core jurisdiction of the Superior Court pursuant to Section 96. We have to stop somewhere, so we'll look at the first criteria on the test today, and we'll look at the rest of the criteria next week. So, first thing we mentioned in the previous capsule is that a power can generally be delegated by the government, but it can only be delegated once. So the legislative branch is going to have a wide ability to delegate a power to an entity that is essentially unelected. So in my example, right, the legislative branch has the ability to pass rules regarding car accidents. One of the things that it can do is to create the car tribunal, as I said, but then it can say that the car tribunal or the car commission is going to have the power to create the rules regarding cars, again because of the principles of administrative law that we looked at in the previous capsule, such as a tribunal having a specialized expertise. So the government might think that, right, these people have a specialized expertise in car accidents, and therefore they are well suited to make up the rules regarding cars. And therefore the government's going to provide that these rules are made by an administrative body, and that's allowed. And the administrative body is going to create administrative rules that essentially have the same texture as the rules that would otherwise have been passed by the state. That's interesting because it removes these rules, the creation of these rules, from the purview of the democratic wills of the electors, because these people elected the government to pass laws, and then if the government gives a bureaucrat the ability to create the rules, then that bureaucrat is not subject to the same democratic pressure. Nonetheless, the government has wide ability to do that. But once a power has been delegated, as we said, it can only be delegated once, and so that decision maker or that rule creator does not have the power to subsequently delegate that power to someone else, ostensibly for the reason I mentioned, ostensibly because they don't have the democratic legitimacy to subsequently redelegate that power. We have what we call discretionary decisions, and these are decisions where you'll have a wider ambit provided for under the statute. So for instance, the statute can say the car tribunal is going to award compensation for car accidents if criteria 1 to 4 are met. That is not a discretionary power because it's constricted. The car tribunal doesn't award compensation when it thinks it's fair or proper to do that. It only does so when criteria 1 to 4 are met. However, you could have a rule that says, but then the car tribunal, to the extent that it's consistent with the principles of fundamental justice, can issue exceptional compensation, and that would be a more discretionary power, because then there are no criteria. Other examples might include, right, the decision of a minister. That's a discretionary decision. Generally, these decisions are not removed from judicial review, because as we said under Section 96, you have a constitutional right to go to court that cannot really be taken away. The government can limit it. The government can say you go to the car tribunal instead of the Superior Court, and then if you get into a car accident, you got to go there instead. That limits your ability to go to the Superior Court. The government might say, right, you have to go to the car appeal tribunal in my example earlier. And also because of the principles we saw regarding judicial review, the court's ability is further limited even when you get there. So you have, as we said, an ability to eventually go to the Superior Court. Once you get through the hurdles, once you go through the car tribunal, then the car appeal tribunal, you generally retain your Section 96 right to go to the Superior Court and say, all these people got it wrong. However, that ability is further limited by the standard of review. because generally what will apply is reasonableness, and generally decisions are reasonable because that's, as we said, a very deferential standard. It's a standard that allows for a wide range of decisions to be made, and therefore most decisions are going to count as reasonable. So in all these ways, the government can constrict your ability to go to the superior court, but generally cannot oust it. So it cannot say, we vest the full power of the superior court upon the car tribunal and therefore fully prevent you from seeking judicial review. Again, because you have a constitutional right to seek judicial review pursuant to Section 96, which also provides for, as I said, the inherent power of the superior court, which is its power to be a default court. Its power to be the place you go if you don't know where to go. There's no other statute that says you've got to go somewhere else. If you have a discretionary power, you still have that right. However, the way in which we account for the fact that the government clearly has an intent for the administrative decision maker to be left alone, to have more discretion, in other words, is with the standard of review. So generally that will be subject to reasonableness review, and therefore significant deference from the court system. As we said, administrative law generally applies to the executive branch of government in the sense that the legislative branch is going to pass the laws, and then the executive branch, which is most of the people working for the government, are going to apply these laws. They're going to decide first whether they have the power to make a decision, which is something that's reviewable, can be not the case, and then they'll make the decision, and that decision has to comport with various things that are amenable to judicial review, such as procedural fairness. In some situation, you have what we call a crown prerogative, which is not reviewable. So this page 27, 28, not something you have to worry all that much about. And even that can be limited by what we'll look at later on in the term as the doctrine of legitimate expectations, where the government has created an expectation that there is a limit to a power that might not otherwise be limited. One limitation of the powers that can be delegated by government is that they can't be fully delegated. So the government couldn't delegate all of its power, abdicate them, quote unquote, as we say, to administrative decision makers. That would not be allowed. So you'll recall we said, the government can limit your ability to go to superior court by creating all these tribunals and by providing in the statute for fewer rights of appeal or more deference upon judicial review. And the government's allowed to do that. However, there's a further limitation on what we call core powers of the superior court. And these are things that cannot be removed. So things where the government could not create a new tribunal because that's part of the protected jurisdiction of the superior court. Why is that? It's because the government, when it creates the car tribunal, as I said, creates an entity that is not independent from government. So it passes a law that says, we create the car tribunal, and then the government, pursuant to that law, decides who sits on there, decides what the rules are. And so essentially the government creates a non-independent body from it, It has to be independent in some way, for it to be constitutional, but not a fully independent body in a constitutional sense as the courts are, Because the court, pursuant to the Constitution, act as a check and balance on the power of the government, And they strike down laws when the government doesn't have the power to pass them. It's because they're independent, And therefore they act as a check that the government actually exercises the power that it has. When the government creates a car tribunal, it creates an entity to make a decision instead of the superior court that does not have that constitutional independence. And that can be bad because then, theoretically, the government could create, 25 tribunals for everything, and then the superior court would have nothing, and that would be a way to indirectly remove that constitutional check on the power of the government. And of course, that's bad. And so it's not constitutionally permissible. For that reason, there are things that are within the core jurisdiction of the superior court that cannot be removed, where the government cannot create a tribunal to adjudicate that. Generally, and you have the test in more detail there, generally these are things that were within the power of the Superior Court at the time of Confederation. And that's significant because most things are not within the power of the Superior Court at the time of Confederation, because the role of government has evolved very significantly since, right? And most of the things that now are part of government were not in 1867, right? Such as welfare state, such as, right, protections for injured workers, and therefore these are all things that were not within that power at Confederation, and therefore can be delegated to an administrative body. So you can have, right, the Car Tribunal, you can have the Injured Workers Tribunal, all sorts of things, as long as they, right, the Welfare Tribunal, as long as they were not powers at Confederation. That power, nonetheless, is going to be broadly construed, so it can evolve over time, right, but can't be something that was not exercised at the time of Confederation, and last, has to be an exclusive power, right? So power that was exercised exclusively by the Superior Court. You have the detailed definition in the book. For our purposes, we don't have to get into that. Essentially, if it's exercised concurrently by something else, it doesn't count as within the core jurisdiction of the Superior Court. And that's the first part of the test, and as I said, we'll look at the other ones next week.